See you guys.
In a criminal offense, you have to prove two things: an actus reus and the mens rea. The actus rea being the guilty act, and the mens rea being the guilty mind. So Diane Magus, counsel for Chris Barber, made a clever argument, I think, when she claimed that because her client was accused of counseling, as part of the offense, the words must be introduced by the Crown, and she says that is the actus reus of the offense, the counseling words.
Day 36 of the Chris Barber and Tamara Lich trial was entirely consumed by a dispute between the Crown and defense teams over the introduction of an evidentiary exhibit from the prosecution. Robert Krychek here in Ottawa, Ontario for Rebel News. Both Chris Barber and Tamara Lich are being charged with a series of crimes for their involvement with the Freedom Convoy of 2022. You all remember it. It was a massive, peaceful demonstration and protest involving civil disobedience here in downtown Ottawa, primarily in front of Parliament Hill, in broad opposition to what I have dubbed the COVID-19 enterprise, a massive apparatus of surveillance and control in the form of orders, decrees, and mandates issued by all levels of government, ostensibly in the pursuit of so-called public health. So the dispute revolves around the comprehensiveness, the breadth of a series of videos produced by Tamara Lich in selfie format and published to her Facebook in the context of the Freedom Convoy. The prosecution seeks to introduce as evidence a particular video or handful of videos, whereas the defense wants the exhibit to include other videos for the purpose of comprehensiveness and fairness, stating that the inclusion of all of the videos they want to have added to this evidentiary exhibit will provide the complete context for the statements being examined made by Tamara Lich. One novel aspect of this trial, which occurred during today's proceedings, was Justice Heather Perkins McVeigh, the judge overseeing this trial, the trier of fact here, stating that this dispute over the comprehensiveness or narrowness of an evidentiary exhibit being submitted by the prosecution in the form of video selfies produced by Tamara Lich and published to her Facebook page is not something that people in the past who wrote the laws governing evidentiary submissions had contemplated. In other words, there is a technological novelty to this particular dispute, which is something unique to our times. Now, folks, remember, we cannot do this in the field journalism, this original reporting at Rebel News without your generous and appreciated financial support. So please visit tamaratrial.com, donate what you can, and stay up to date with our ongoing coverage. So I'm here with Mark from the Democracy Fund, our sister organization. And Mark, I want to ask you about the rationale for the defense to request the consolidation of these Tamara Lich selfie videos that she posted to Facebook into one evidentiary exhibit, as opposed to the prosecution's desire to introduce particular videos in isolated form. Why don't you tell us why that's important and what the potential impact is if the defense were to introduce those videos that they say are omitted on their own as their own evidentiary exhibits for the defense?
Sure. So basically, I think what the defense is concerned about is having Tamara Lich authenticate the videos and the statements herself, putting her on the stand subjects her to cross-examination. So that's something tactically that the defense, I think, is loath to do. They don't think it's necessary. They don't want to expose her to cross-examination. So the effort here is to have those statements and videos introduced by way of I think it's the total statements rule. You heard some discussion, and there was some back and forth with the judge about the jurisprudence that governs it, but basically it allows the defense, they would argue, to have the totality of the statements and the video introduced with the Crown's package.
Diane Magus, defense counsel for Chris Barber, was offering her argument for, again, also to consolidate these videos into one, right? So why don't you share with our audience what was Magus arguing, what was her rationale?
Sure. So in a criminal offense, you have to prove two things: an actus reus and the mens rea. The actus rea being the guilty act, and the mens rea being the guilty mind. So Diane Magus, counsel for Chris Barber, made a clever argument, I think, when she claimed that because her client was accused of counseling, as part of the offense, the words must be introduced by the Crown, and she says that is the actus reus of the offense, the counseling words. So as for fairness, she wants the totality of the counseling statements introduced. So she's making an actus reus argument, essentially.
This dispute over the prosecution's submission of an evidentiary exhibit will continue into tomorrow because neither the prosecution nor defense teams have completed or ended their arguments in favor of their respective positions. So even if these arguments are completed by tomorrow, the judge may not decide. She may wish to take time for herself to determine how she wants to rule over this particular dispute. However, arguments can still be presented by the defense tomorrow, assuming that the arguments presented by the two sides over this particular dispute come to an end. So the trial will continue as scheduled through tomorrow and on Friday.